People living further than 1,500 feet from a proposed fracking site are also allowed to request a public hearing, but the rules are unclear about when requested public hearings would be granted. I'm very nervous, but I have a well, so I'm very worried about it.
Take a deep breath there.
Just because the frack pad is not on my front lawn does not mean that it will not affect my home, my life, my livelihood, or my well. If our neighbors lease their land, or if the forced pooling means that I am forcibly included in a drilling site, we are limited by the IDNR's definition. Though it may move quite slowly, groundwater moves, so any contamination of shallow groundwater from drilling or fracking operations would move with the slow flow of groundwater. Which direction will it flow? How far will it flow? Getting that answer would require careful scientific study at significant expense. Clearly, the state cannot expect individual landowners to undertake such studies before they request public hearings. Yet they would have to in order to argue for a public hearing to just begin the process of ensuring that the water in their wells is protected. And of course, Illinoisans can expect the oil and gas industry to badger the hearing officers tasked with deciding on whether or not individuals have standing to request public hearings. Thank you.
Okay, thank you, ma'am. Okay, Mr. Yancey.
Bob Yancey, Y-A-N-C-E-Y, Bond County. My statement is in regards to the water source management plan. It seems to me what I've been able to learn is that after just a minimum of info, that the operators can, or producers can basically just go wherever they want and take it. I haven't been able to find any info on how much they can take out of creeks and rivers. I know in Texas they've taken so much that the fish lay dying in heaps. Some towns have been forced to ration water. I mean, I have to haul water. Will I go to town and will there be 20 tanker trucks in front of me? I don't know. It's anyway, I hope all that don't happen. That's it.
Okay, well, thank you, Mr. Yancey. All right, let's see here. Next, after Ms. Baker, will be Jean K-R-A-H-L, it looks like. You can come on up and have a seat here. All right, Ms. Baker.
Hi, my name is Jerwane Baker, B-A-K-E-R.
Spell that first name too.
Jerwane, G-I-R-W-A-N-A, Baker, B-A-K-E-R, got it? All right, and I'm here with Iron Student Network and Fair Economy Illinois. Oh, yeah, Fair Economy Illinois, I'm sorry. I have 2 points that I want to point out on my comment. First, I want to address the non-water fracking and how critical it is that non-water fracking not be exempt from the rules. The law defines high-volume fracking based on the number of gallons of base fluid. Now, this means that high-volume fracking is between 80,000 and 300,000 gallons total. The problem is that gallons are units of volume used to measure liquid. But what if that liquid isn't used in fracking? Not all fracking-based material can be measured by gallons. If non-water-based fluids are accounted for as liquid gallons, the gallonage total will fall below the threshold set by the rules. Suddenly, a fracking operation will no longer be considered high volume, even though the operation is comparable in scale and therefore risk to a high volume fracking in terms of chemical use, pressures, or other measures. Why is this important? If fracking operation uses less than 300 gallons of fluid, they are considered medium volume fracking and they are exempt from all the regulations in the law. Either IDNR has intentionally created a loophole to exempt the majority of fracking operations from regulations, fracking operations from regulations, or it's simply inept and lazy, either of which could have disastrous outcomes from Illinois residents. My second comment has to do with the unfair public hearing process. First of all, Section 245.230E creates a loophole whereby the 60-day review period for permit application begins to run even before the application is deemed complete by the department. This is simply inviting companies to submit incomplete permits as a way of avoiding public oversight and comments. IDNR needs to ensure that the 60-day review period only begins to run after IDNR deems applications as being complete. Another rule I want to point out is that the rules do not require the IDNN to testify under oath and be available for cross-examination. How is the public to be assured that there is concern, how is the public to be assured that their concerns will be addressed if IDNR only has to sit and listen to them without responding? Another rule forces petitioners to present their concerns in the context of the rules. IDNR should be concerned about the content of the complaint, not the technicalities. Sorry about that. All right, and that's it.
All right, thank you, Ms. Clayton. Carl, is it?
Well, that's my human's name. I'm actually a monkey. Bonobo, technically.
Oh, you fit right in.
Yeah. Krahl is what he likes to go by. So I'm not native to this area, as you can see, but I care about it. And I feel like that's what solidarity is about, that I can fight and argue on behalf of animals and people that are in this area, even if I'm not from it. I want to say that I think fracking is a part of a wider project of seizing land and resources from poor people that are riddled in debt and don't have any other means to sustain themselves. And I think that we as people in Southern Illinois don't want to invite the kinds of corporations that you are all trying to legislate on behalf of here, right? These are beings that roam the earth searching for nothing but profit without any concern for the lives and livelihoods of the people that are subject to what they are producing. And in this case, that is a ton of pollution. We're seeing it everywhere. We're seeing earthquakes actually being produced. This is well documented. And now here, so you can make a note of this fits in with the technical things, right? We're between two major seismic zones, right? Can you guys say it with me? There is scientific evidence to show that fracking causes earthquakes, and we are between two major seismic zones. It is scandalous that you would even consider doing this here. And you all wear ties, and I wear a monkey suit, and I look like the weirdo, but no, look, you are the irresponsible ones here that are even considering doing this. And I think, you know, you say, of course, this is just about the regulations. Oh yes, it's just about the regulations. Well, implementing the regulations is doing something. With respect to regulations, you're just doing your jobs, right? And that's the same kind of sales pitch that these industry executives are making, or these landmen are making to poor people. Well, it'll bring you jobs, it'll bring you some kind of financial security, right? But one of the things that I think is particularly interesting is that among themselves, these industry executives have called this a Ponzi scheme. I don't know if you guys have seen this. This is years old. I don't know if everybody here that's maybe considering leasing their land has seen this, but this is from Forbes magazine, not particularly a magazine of the left, right? In emails amongst themselves, energy executives, industry lawyers, state geologists, and market analysts question the economics of shale gas and hint at impropriety. They call company statements about the value of fines a Ponzi scheme, invoke Enron, and cite a mentality of conning Wall Street while drilling fast before the jig is up. Well, look, when the jig is up, it isn't these dudes in suits or whoever it is that's trying to sell you or trying to take your land that's going to be without money. It's going to be you. It's going to be poor people that are left poor for another generation. And yeah, I think that the Ponzi scheme should end in Illinois, and that everybody up here should take it upon themselves to say, look, we can't regulate this. It can't be regulated safely. This can't be made safe, and that has to stop in Illinois. Thank you.
Okay, thank you, sir.